The topic today is Indian affairs, and it's Indian affairs in a constitutional sense. And that actually is a very different topic from the general topic of Indian law, which is massive. And the fact of that distinction allows me to make an introductory observation that I hope will guide the way that we think about the remainder of the materials that I'm going to present. The Constitution is a document created by us, the people, to delegate to a newly invented central government a set of powers over us. And there's extensive discussion of how that government's going to be structured, what it's going to be able to do, and then in the Bill of Rights, specific things it's not going to be able to do. There's also a lot of discussion in the Constitution about the states, because the states pre-exist and are a part of the new federal structure. So the constitutional framers had to figure out, well, how do the states relate to the federal government? If there are inconsistencies in legislation, whose legislation wins? Answer, the federal legislation, that's the Supremacy Clause. Well, okay, but you know, there are certain things that the federal government can do. There must be certain things that the state government can do. Those powers are reserved to them, right? Well, yeah, that's the 10th Amendment we put in to make sure that everybody understands that. Lots of talk about the federal government and the state governments, and then most of, if not all of, subsequent American constitutional history is the working out of those terms, federal and state government relationship to each other, and the powers that each of those constituent parts of the federal structure retains or has after the Constitution is ratified, powers vis-a-vis each other, but powers vis-a-vis us as citizens and other people who come in as non-citizens and the rest of the world, etc. Where are Indians in all this? Well, the answer is they weren't at Philadelphia, the tribes. There were hundreds of tribal governments in existence when Europeans first arrived. They continued to exist during the whole of the colonial period, most of them. They continued to exist during the War of Independence. Some of them took sides. Some of them allied themselves with the British, others with the Americans. Peace treaties were signed at the end of the war, and new treaties were signed between the new United States Confederation government and the tribes. And then when the Constitution was put together, the new federal government and the state governments had to sort out who was going to conduct relations with the tribes, but there was never thought given to the tribes themselves forming part of the new American Union. The tribes aren't constitutional political bodies. They're extra-constitutional. They exist outside the scope of the Constitution. So this is to say that in a brief discussion on the Constitution and Indians, since we're in a series on constitutional law, there's less to say than you might think. If this were a lecture on Indian law in general, I would never let you leave. If it were a lecture on foreign affairs, maybe there'd be more to say, tribes' rights, international law issues, that sort of thing. But as a matter of constitutional law, the topics are fairly discrete. And I can cover them at least in fairly cursory form fairly quickly. Indians appear in the Constitution. We see them in Article 1, Section 2. That's the provision that sorts out how the Congress of the United States is going to be constituted, who gets counted, and the answer is we do a census and figure out the whole number of free persons. This is the initial formulation, including those bound to service for a term of years and excluding Indians not taxed, 3/5 of all other persons. So if you have Indians within the bounds of a congressional district, unless they're taxed, which was to say effectively unless they're citizens who no longer have relations with their tribes, then you don't count them. They don't count towards figuring out how many representatives you get, either in whole or in part, as 3/5. Indians show up again in Article 1, Section 8, which is the article that lists the things that Congress gets to do. And one of the first of those is to regulate, Congress shall have the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. Now that with the among the several states language is what we think of as the Interstate Commerce Clause, or now we just call it the Commerce Clause. But that last bit's there too, and that's what Indian lawyers will tell you we call the Indian Commerce Clause. So Congress is granted power to regulate commerce with the Indian tribes. We'll talk in a minute about what that means. There's a war power granted to Congress in Article 1, Section 8, and that's relevant to the federal relation with tribes, because if things go wrong, somebody has to raise the army. It's going to be Congress and not the states who do that. The federal government also has the power to make treaties. And treaty making through 1871 is the principal means of effectuating essentially foreign policy towards tribes. That's how deals get cut. The executive negotiates a treaty with the tribe sends its reps, both sides sign it, both sides endorse it or ratify it according to their provisions, and that makes it enforceable. And that power is entrusted to the federal government as well. I'll talk about why again in a minute. And then Indians show up again one last time in the Constitution in the 14th Amendment. The 14th Amendment, Section 1 of which was designed to reverse part of the Dred Scott decision, begins, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Well, where's Indians? And the answer is they are the ones referenced in the phrase subject to the jurisdiction thereof. So if you're an Indian and born within the territorial limits of the United States, at the time of the ratification of the 14th Amendment, you weren't necessarily subject to U.S. jurisdiction. You're not a citizen of the United States. You're not a citizen of a state. You're a citizen of your tribe. You happen to occupy lands within the territorial limits of the United States, but you owe no particular allegiance to the government of the United States. You're not subject to its jurisdictional power. You're subject to whatever treaty obligations your tribe has incurred vis-a-vis the United States. But you don't acquire citizenship under the 14th Amendment. This was for freed slaves and other people who may have come into the United States and had children there. And that's Indians in the Constitution. Now, let's set the framework for what all of these provisions together was intended to accomplish. I've already alluded to half of my answer, which is they're intended to establish a framework for relating to a people who are politically separate, who exist as political communities outside the bounds of the Constitution. They're not states, they're not counties, they're separate political entities. So the Constitution's here and the tribes are over here. That's a point I'll return to momentarily. We'll see how that plays out in constitutional law decisions. The other is the allocation of power to sort of shepherd relations with these separate political communities within the constitutional structure. And to explain how that's resolved by these provisions, I need to back up a little bit historically. We'll go back to the days of Old England. The British colonial governments themselves claimed the power to conduct relations with the tribes within their claimed charter limits. So you have treaties between Virginia and various tribes, treaties between New York and the colony of New York and various tribes. But the Crown was never entirely happy with this, and it turned out to be the source of some conflict and may well have been a contributing factor to the 7 Years' War, which we used to call the French and Indian War, which is the war between Britain and the colonies and France and its Indian allies over here, but was also fought out in other parts of the world. And what the Crown decided, the British Crown, at the end of the 7 Years' War, was that he ought to take control of Indian relations, essentially. And so the British Crown, George III, issued a royal proclamation in October 1763 that said, all right, look, cut it out. Okay, here's what we're going to do. From now on, there's going to be a line that runs down the ridge of the Appalachian Mountains. And everything west of that line is reserved to the Indians. And they're under my care and protection. If you're not an Indian, if you're a British colonial, I want you out of there immediately. And governors of colonies no longer have the power to make land grants to people in the areas that are, the territories that are reserved for the Indians. Now, this took sort of control of took the power to wheel and deal away from colonial governors. It infuriated a lot of wealthy landowners who were hoping to make a fortune buying and selling lands in these newly acquired, as they viewed it, from the French Western territories. And it was a trigger for the American Revolution, this denial of access to these lands to these folks. When the revolution started and then was successfully prosecuted, there was an expectation on the part of a lot of these people that the new states would now take control, and the rich locals controlled the state governments and they could get into the Indian land business again. But Congress wasn't sure that was a good idea. You know, once they were in charge and they realized the potential for irritating the tribes, inspiring new warfare, they thought, well, maybe what the king did wasn't such a bad idea. Maybe we should retain central control of this. And so a lot of the early discussion, the Confederation period and the Constitution drafting period, is an attempt to resolve that. Who really should be in charge of Indian affairs? In the Confederation articles, they came up with a provision that is almost impossible entirely to understand. But what it says is the U.S., in the articles, says the U.S. Congress, which was the sole government of the sole central government, the U.S. Congress has sole and exclusive right and power of regulating the trade and managing all affairs with the Indians. Now that would have been fine if there had been a period there, but there wasn't. They put a comma and continued, not members of the states, provided that the legislative right of any state within its own limits be not infringed or violated. And that's where they put the period. So, does New York have the power to deal with Indians? I don't know. They suggest, New York's argument would have been, well, yeah, because we have the legislative right to deal with Indians within our own limits, and the federal position could have been, no, you don't. I mean, if you had the right, we couldn't interfere with it, but you don't have the right. And so this was the cause of some controversy even at the time. When it came time to put the Constitution together, the decision that the framers made was to keep the states out of it. Let's federalize the whole thing. And that's why in the Commerce Clause in Article 1, Section 8, they included a provision that said that the Congress shall have the power to regulate commerce with the Indian tribes. The Congress shall have power to regulate commerce with the Indian tribes. And since that time, and the war power and the treaty power, which were the principal means of effectuating policy, relations through treaties, and if they failed, then war. And I should say, in investing the war and treaty power in the federal government, they also effectively divested the states of any means of enforcing any sort of meaningful treaty Indian policy. You know, you can be mad if you're Georgia that the Cherokees won't leave, but you can't constitutionally raise an army to kick them out. All you can do is stand at the border and shake your fist, because the federal government is the only constitutionally empowered body to raise an army. Now, so how does this play out then? We have a structure in which the federal government has superintending power over tribes. This is still the rule. Are tribal members citizens now? I say superintending power over, I mean within the federal structure, the federal government has the superintending power to deal with tribes. Are tribal members citizens now? The answer is yes, but again, not because of the 14th Amendment. A number of tribal members became citizens through individual treaties with their tribes, which conferred United States citizenship on members of the signatory tribes. But tribal members as a whole didn't become U.S. citizens until, wait for it, 1924, when Congress passed a statute, the Indian Citizenship of 1924, which conferred U.S. citizenship on all persons born in the United States, including Indians, without interfering with, it says explicitly, rights that they might have under treaties. Are tribes subject to the Constitution today? No. That rule also remains. There's an 1896 decision called Talton versus Mays. It's a Cherokee Nation decision where a Cherokee tribal member was indicted by a grand jury for commission of felony. And he argued that the grand jury didn't have enough people on it, that the U.S. Constitution required that there be so many people on an indicting grand jury, and this one fell short. That case went to the Supreme Court, and the Supreme Court said, you're right about the number that the Constitution requires. You're wrong in your argument that that makes any difference to your case, because the Cherokee Nation are not subject to the Bill of Rights of the Constitution. Cherokee Nation are an independent political entity exercising inherent power. They weren't at Philadelphia. It's the Indian version of the Barron versus Baltimore decision, which said that the states aren't subject to the Bill of Rights either. The Bill of Rights only limits the action of the federal government created under the U.S. Constitution. Does that mean that there are no limitations, constitutional-like limitations, Bill of Rights-like limitations on tribes? No, but again, that's a later phenomenon than you might think. 1968, Congress passed a statute called the Indian Civil Rights Act, which applies by statute most of the provisions of the Bill of Rights to the tribes. Some it doesn't. For instance, the Establishment Clause, if a tribe wants to establish a religion, it can. There's no, unless its own constitution prohibits it, there's no federal limitation on tribes becoming theocracies. And some effectively are, some of the Pueblos who have Catholic cemeteries that are owned by the public. All of this is constitutional, and so it fits within the theme of the conference. But it's all just sort of the tip of the iceberg on issues of relations, Indian, federal relations, Indian state relations, a much larger topic than we have time for today. But I hope you found this introduction to just how interesting it is interesting. Thank you.
Freedom 101 is made possible by generous support from Woody Young and the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.